Madam Chair, the floor is yours when you're ready to call us to order.
Great, thank you. So let's begin. This is a meeting of the Regulation and Discipline Committee. We are going to start in open session and then we will proceed to closed session. And let's start with the roll call. Justin, if you could please.
Sure. Broughton.
Here.
Cisneros.
Here.
Is it? I can speak louder. De La Cruz. Duran.
Here.
Ganong.
Here.
Pertula. Selig. Shelby.
Present.
Sowell.
Here.
Stallings.
Here.
Chen.
Here.
We have a quorum.
Great. Well, welcome everybody. The first item on our agenda is public comment. If there's any member of the public that would like to make a public comment on an item that is on the agenda, please use the raise your hand button on Zoom and staff will call on you in order.
At this time, I do not see any hands raised. Oh,
I
there.
do see one hand raised now.
So it is on the phone.
Okay, and is that caller unmuted?
Yeah, 415, you can unmute yourself and you have 3 minutes. Caller, can you speak? Area code 415-515. It looks like you're unmuted.
Sir, if you're attempting to speak, sir or ma'am, if you're attempting to speak, your mic was muted and then it was unmuted. It's unmuted now. Can you speak, please? Otherwise, we're going to need to move on. We're not hearing anything. I think we're going to need to move on.
Okay. Is there anyone else who's raised their hand for public comment?
I don't see anyone.
Okay. The next item on the agenda is the chair's oral report. I do have a brief one. First of all, would like to thank the outgoing chair, Brandon Stallings, for all of the important work that he has done to get us in the place where we are today, as we just saw at the executive committee meeting. Strengthening the oversight of the Chief Trial Counsel has been an important goal under Brandon's tenure, and we have accomplished that with amendment to the RAD charter. Thank you so much for all your work, Brandon. I have big shoes to fill. Vice Chair Jose Cisneros and I are off to a great start working together with our new Chief Trial Counsel, George Cardona, who we'll hear from later today in closed session, as well as an open session. For those of you who are not able to attend the executive committee meeting just now, the executive committee just approved amendments to the RAD charter to strengthen our oversight of the Chief Trial Counsel. That includes approval of an annual performance plan for the Chief Trial Counsel, completion of an annual performance evaluation, as well as quarterly meetings with the Chief Trial Counsel, the chair and the vice chair to go over a dashboard of metrics. The first dashboard of metrics is going to be generated in January, I understand, to cover the last quarter of 2021. And so we're looking forward to that. And then I would end with a note of gratitude and special appreciation for our Special Deputy Trial Counsel, SDTC Administrator, Jeff Delcero, whose last report as an administrator will be given today. Jeff has played a key role in further refining the conflict system through Rule 2201 changes and through other substantive and administrative leadership. We will miss his work as an administrator. The good news is he'll remain on as an SDTC starting January 1st. So special thanks to Jeff. And with that, that concludes my oral report, and we will move into the open session consent agenda. Item 2A is the amendment to Rule of Procedure 2201, return from public comment and request for approval. Any discussion before I ask for motion? Okay, do I have a motion?
I'll move it, Madam Chair. It's Duran.
This is Jose.
Thank you. And a second from Jose. Okay, Justin, please call the roll.
Broughton,
Yes.
Cisneros. Aye. De La Cruz, Duran,
Yes.
Ganong,
Yes.
Gula, Salig,
Yes.
Shelby,
Aye.
Sol,
Aye.
Stallings,
Yes.
passes.
Thank you. Next, we'll move to our open session regular agenda. First up is item 3A, the formal advisory ethics opinion 2021-207, request for approval for publication. Andrew Tuft from the Office of Professional Competence will be presenting this item remotely.
Good morning, everybody. Can you hear me okay?
Yes, we can.
Okay, great. This item requests approval for the publication of formal ethics opinion 2021-207. And this ethics opinion addresses the topic of what are the ethical obligations of a lawyer for a client with diminished capacity. The opinion went out for public comment twice, and during the second round of public comment, comments were received from 10 different commenters. The majority of the commenters expressed support for the opinion's publication. There was one thematic comment, as more than one commenter suggested that section 4 of this opinion, which addresses whether and how to obtain advanced informed consent from a client to disclose relevant confidential information should the client later suffer from diminished capacity, should be broken out into a separate opinion. The same suggestion was made during the first round of public comment, and COPRAC carefully considered that option, but declined to do so. The committee believes the issue of whether and when a lawyer may ethically take protective action when a client is exposed to physical, emotional, or financial harm is central to representing clients with diminished capacity. And in California, the protective action issue cannot be adequately addressed without attending to the issue of advanced informed consent. And so the committee strongly believes that the discussion of advanced informed consent and scenario 4 is therefore tightly linked both doctrinally and practically to the analysis of the remainder of the opinion as set forth in scenarios 1 through 3. And so the committee feels that eliminating this discussion would substantially reduce the value of the opinion to practitioners. There was one critical comment, which was signed by a group of legal services organizations. That comment argues that the opinion's discussion of advanced informed consent is incorrect. In particular, this comment believes that a lawyer effectuating an advanced informed consent must always come back to the client at the time of disclosure and give the client notice of the lawyer's intention to disclose the confidential information. The committee disagrees with that conclusion, and they feel strongly that it would be counterintuitive for that to be the law, as it would render the idea of advanced consent meaningless because it would require all consent to be contemporaneous with the disclosure. The committee observes that the opinion makes clear that the concept of advanced informed consent is both recognized and improved in the rules of professional conduct and in case law. And in addition, the opinion expressly states that the consent must be revocable at any time, and the right to revoke should be highlighted in the informed consent, which the committee recommends should be in writing, even though the rules of professional conduct only do not require that such consent be in writing. And so after considering all the comments received, the committee is requesting approval to publish this opinion on the State Bar's website.
Thank you, Mr. Tuft. Any questions, discussion? So I do have a question. Just to clarify on that last point you were discussing about COPRAC not requiring that there be notice given before disclosure, that doesn't preclude an informed advance consent from including such a requirement, right? Like a lawyer could and a client could agree to that, notwithstanding what's in this opinion.
That's correct. And I may have misheard you, but let me clarify. Consent must be given in
Right.
order to
This
share
is just
confidential
notice.
information. So, and what you're alluding to, as I understand what you're saying, is actually absolutely correct. And in fact, it's contained in the opinion. The client and the lawyer could agree, this is how I want you to protect me, lawyer, should this eventual circumstance arise. However, before you do that, you must always come back to me to make sure I'm okay with what we're agreeing to today. And that is recognized in the opinion. However, the rules do not require that, but the committee does acknowledge that that is something that the client and the lawyer can freely enter into. I think I'm answering your question. Is that what you
Yes.
were asking? Yeah,
That was. Thank
absolutely.
you.
And that's an important element of this opinion.
Other questions or comments? Okay, do we have a motion for publication? Or I guess we should pull up the language of the resolution.
This is Jose. I'll make the motion.
Thanks, Jose. Do we have a second?
Shelby, I'll second.
Thank you. Any other comments before we call roll? Okay, Justin, if you could call roll, please.
Broughton,
Yes.
Cisneros,
Aye.
De La Cruz, Duran,
Yes.
Ganong,
Yes.
Pertula, Seleg, Shelby,
Aye.
Sol,
Aye.
Stallings.
Yes.
It passes.
Thank you. Next up is item 3B, proposed amendments to the client security fund rules regarding electronic service. This is a request to circulate for public comment. And Lori Malak and Matthew Zaywell from the Office of Professional Support and Client Protection will be presenting this item remotely. So the floor is yours.
Good morning, everybody. My name is Lori Mellock. I am the Director of the Office of Professional Support and Client Protection. I'm here with Matt Zaywall, who is the Supervising Counsel for the Client Security Fund. This item is a proposal to amend the Client Security Fund rules to allow for electronic service and for electronic signatures. Currently, the Client Security Fund serves everything by first-class mail, and this would allow us to serve by electronic service. We've essentially mirrored the rules that have been authorized for disciplinary matters, but we've adapted them for the Client Security Fund administrative procedures. And this is to allow the matter to go out for public comment. Are there any questions?
Okay, not seeing any. Do we have a motion?
I'll move the item.
Thanks, Mark. Do we have a second?
Sean.
If there was a second, I didn't hear it.
This is Arnie. I'll second it.
Okay, thanks, Arnie. Justin, could you call roll, please?
Sure. Broughton,
Yes.
Cisneros,
Aye.
De La Cruz, Duran,
Aye.
Ganong,
Yes.
Pertula, Seleg, Shelby,
Aye.
Sol,
Aye.
Stallings.
Yes.
It passes.
Great, thank you very much.
Thank you.
So the next item is item 3C. It's a proposed amendment to rules 5.65, 5.337, and 5.345 of the rules of procedure. This is also a request for public comment, and our Chief Trial Counsel, George Cardona, will be presenting this item. George, the floor is yours.
Thanks. So this is a proposal for amendments to a series of 3 rules to fill what OCTC perceives as gaps in authorized discovery in state bar court proceedings. So first, with respect to Rule 5.65, there are actually 2 pieces there. The rules currently provide a process for respondent attorneys to request reductions, waivers, or extensions of time to pay monetary sanctions. But there's no discovery provision that would permit OCTC to seek discovery in response to such requests. So new proposed section 5.65C4 would add authorization for discovery of financial records or other proof of financial hardship to allow us to address those types of requests. The second piece, we often charge, the State Bar Court often orders compliance with California Rule of Court 9.20. In connection with discipline that the State Bar Court is imposing. A violation of those, that is typically charged as a violation of Business and Professions Code 6103, which is violation of a court order. Unfortunately, for those types of violations, the discovery rules that would apply to violations of Supreme Court orders for compliance with Rule 9.20 do not apply. The new proposed 5.65C5 would correct this, permitting discovery in those types of proceedings, just as in proceedings to enforce Supreme Court section Rule 9.20 orders. With respect to Rule 5.337B, which is in fact the rule governing discovery in 9.20 proceedings, we're proposing minor modifications to better align the discovery permitted with the full set of notice, delivery, and refund requirements imposed by Rule 9.20. And for Rule 5.345, which deals with criminal conviction referral matters, those are initiated by transmittal of a certified record of conviction. Because referral is required within 30 days of receipt of the certified record, there's a very limited or no investigation period. And as a result, we generally have insufficient time to establish facts and circumstances underlying the offense, which are often relevant to whether it involves moral turpitude or constitutes conduct otherwise warranting discipline. The proposed 5.345D would authorize OCTC, after service of the answer, to take one deposition of the respondent to inquire into such facts and circumstances in connection with the disciplinary proceeding. So we're requesting circulation of these proposed amendments to all 3 rules for public comment for 45 days.
Thank you, Mr. Cardona. Any questions?
Partly to test if my microphone is working now, I will move the item.
Thank you, Mr. Saleh. We have a second?
That's Jose, I'll second.
Thanks, Jose. Any comments before we call roll? Okay, Justin, if you could please call roll.
Yes.
Cisneros,
Aye.
De La Cruz, Duran,
Aye.
Ganong,
Yes.
Pertula, Seleg,
Yes.
Shelby,
Aye.
Sowell,
Aye.
Stallings.
Yes.
Passes.
Thank you. Next up is item 3D. This is a proposed amendment to Rule 5.80 of the Rules of Procedure. This is also a request for public comment, and Mr. Cardona will present this item as well.
Thank you. So current Rule 5.80B2 provides that in the absence of a signed receipt from the attorney for the notice of disciplinary charges, to proceed by default, OCTC must provide a declaration showing that it took, quote, those additional steps a reasonable person would have taken under the circumstances to provide notice. The proposed amendment would replace this language with more detailed requirements to clarify what steps should be taken to provide notice. For example, identifying and attempting notice to past addresses or via contact information obtained through a web search. The amendments would also add a new 5.80 subsection C to specify that proof of notice efforts can be made through state bar records, and a new 5.80E to specify that proof of notice efforts creates a presumption affecting the burden of producing evidence that the respondent had actual notice. And again, we're requesting circulation of these proposed amendments for public comment for 45 days.
Any questions?
Right, Madam Chair, this is Brandon. I just wanted to take this time to talk to the attorneys who are monitoring this meeting. As a young lawyer, one of the most interesting pieces of advice that I received when going through training was make sure your state bar profile is updated. It's the easiest way to get disbarred. So for everybody listening, make sure your information is relevant and includes all of your most up-to-date info. So hopefully it doesn't come to pass. And with that, I'll move the item.
Thank you. Great tips. Anyone, do we have a second?
I'll second that, Duran.
Thank you. Any comments? Dustin, if you could call vote, please.
Broughton,
Yes.
Cisneros,
Aye.
De La Cruz, Duran,
Aye.
Ganong,
Yes.
Pertula, Saleg, Shelby,
Aye.
Sowell,
Aye.
Stallings. Yes. It passes.
Thank you. The next item is item 3E. This is a proposed amendment to the consumer alert policy to clarify that it applies to felony charges in all courts. And this is a request for adoption, and Mr. Cardona will present this item as well.
Thank you. So in November of 2018, the Board of Trustees amended its policy on consumer alerts to authorize posting of alerts when felony charges are pending against an attorney. The language of the authorized alert was generic and would apply to felonies wherever charged, including federal courts. But the title of the agenda item could be read to suggest a limitation of the policy only to felonies charged in California Superior Courts. As a result of the uncertainty, OCT has declined to post an alert for several attorneys charged with felonies in federal court, even when those felonies have been fairly serious, including, for example, wire fraud charges. We're seeking amendment of the policy to clarify that it applies to felony charges in whatever court they may be lodged. In addition, modification of the alert itself is proposed to clarify that inquiries regarding the charges should be addressed to the court in which the charges are pending, which would have any additional information, rather than to OCTC, which might not. Public comment on board policy isn't required. Given this and what we view as the clarifying nature of the proposed changes, we're seeking referral to the Board of Trustees for adoption without circulation for public comment.
Thank you. Any questions?
This is Sean. I'll move the item.
This is Christine. I'll second.
Thank you. Any questions or comments?
Just a brief comment. For those of us that were around do remember the robust discussion that we had concerning this item. I think I was the only one who ultimately voted against approval. Be that as it may, the situation has changed, at least for me today, so that I will be abstaining from any vote on this issue, but it does not change how I felt about it back then.
Thank you, Mr. Bratton. Mr. Cardona, I do have a question now. I believe we did receive some public comment actually prior to the executive committee session. If you could provide clarification for us as to what it means for felony charges to be filed in state court versus federal court, and whether there's a difference in when the state bar would consider felony charges to have been filed, that would be helpful.
So felony charges would be filed in state court upon the filing of either an information or an indictment alleging those charges. In federal court, it would have to be an indictment that would be filed in federal court to reflect the filing of charges.
Thank
If
you.
this raises the issue that I was discussing earlier on. The way that the rule, and I think how we ultimately voted, was the filing of the charges in state court can be by way of a complaint, not an information or indictment. And that was my objection. Same in federal court. Federal court goes a little bit more quickly, but usually they will proceed via a complaint. It then goes to the grand jury where an indictment will be issued. So the way I understand the rule, it's as the filing of the complaint, any charges, is when this kicks in.
So the policy as it currently reads simply says charged and doesn't specify one way or another whether a complaint constitute a charge. I'm not aware of what the discussion was at the prior meeting.
The way I understand it now, it's simply the filing prior to any probable cause finding with respect to the charges. That was my objection, but of course, the board voted to approve simply the filing of those charges. So that's where it is now, but certainly you can review it. I don't recall the exact rules off the top of my head, but.
So we'll certainly take a look at that. I still think that the amendment is appropriate because I don't think there should be a differentiation between charges in California state court as opposed to, for example, federal charges. And we have seen a number of instances in which there have been serious felony charges filed in federal court, but where we would like to post the notice, but the uncertainty is there.
And Madam Chair, if I may, so my recollection of the prior discussion that Mr. Broughton references, we were trying to find that balance between notifying the public of pending charges, much like a superior court would notify the public through some sort of electronic calendar of charges that are pending against an individual and what individuals are on their criminal calendars. I think in seeking that balance, we add the disclaimer that the filing of criminal charges does not constitute a finding of guilt or professional misconduct. Criminal defendants are presumed to be innocent until proven guilty in a court of law. And so I think it strikes a good balance between notifying the public of information that is publicly accessible, but also reminding them of due process rights.
Thank you. Any other discussion or comment at this point? So it sounds like it would be helpful, given that we're seeking adoption of this amendment to board policy, if we had clarification as to when charges were filed, just for clarity, so that folks know what that means.
So, I mean, there could be differences. Mr. Broughton has raised, be initiated by a complaint. How complaints are filed varies in state court and federal court. In state court, the filing of a complaint is based on an affidavit that sets out probable cause, which I believe I would have to go back and look at my criminal procedure in state court to see if that's the same. The difference between an information and an information then triggers, and I'm going to have to go back to, again, my state court criminal procedure for a while, but I believe an information triggers is that what triggers the preliminary hearing?
You need a preliminary hearing to show probable cause.
Yeah, the complaint generates the necessity for a probable cause finding. Once there is a probable cause finding by way of a preliminary hearing in state court, then the indictment, or excuse me, the information is filed. Indictment comes out of a grand jury, which is hardly ever used in the state court.
And in federal court, the common mechanism of charging is an indictment, which reflects a finding of probable cause by a grand jury. But previous to that, there could be a filing of a complaint, which requires an affidavit setting out probable cause to establish the charges that are set out in the complaint.
Highland, if I may, I would recommend that Rod asks the chief trial counsel to come back with clarification on the definition of charges, as well as an explanation of how that is being applied now. And I think, George, what you're suggesting is irrespective of that issue, you'd like this item to go forward with the principle being that there should be consistency in the application between state and federal court.
Yes, in other words, we can, whatever we're doing, it should be the same whether the charges are pending in state or federal court. And I can certainly come back and clarify when we are seeking that and or propose an amendment to clarify what constitutes charging.
So if Rod is comfortable with doing that, we could move forward with the item and direct the
Yeah.
chief counsel to come back.
I think that makes a lot of sense. I think that so this resolution is focused on consistency, maintaining consistency between state court charges and federal court charges. And then we will get further clarification as to what it means for a felony charge to have been filed.
Madam Chair, if the resolution doesn't need to be amended to that effect, I'll move it. If it does need to be amended, then I move it as amended, but I'm looking at the chief trial counsel who shakes his head.
Yeah, I don't believe the resolution needs to be amended. I'll take the separate direction to come back at your next meeting with more clarification and or a request for a further amendment.
Okay, thank you. This is Duran. I'll move it as presented.
We already moved. I think Sean
Apologize.
moved and Christine seconded.
Oh, thank you.
All right. Are we ready to proceed to a vote? Okay, Justin, if you could please.
Broughton,
Abstain.
Cisneros,
Aye.
De La Cruz, Duran,
Aye.
Ganong,
Yes.
Petula, Selig.
Yes.
Shelby,
Abstain.
So
Aye.
Stallings.
Yes.
It passes.
Thank you. Okay, our final open session item is item 3F. This is the overview of the twice yearly random audit of the Office of Chief Trial Counsel closed cases and Office of Chief Trial Counsel response. And Mr. Cardona will present this item.
Thank you. So I have a very short PowerPoint that if I could, I'd like to pop up that I think will speed the discussion. Thanks. Okay. All right, so briefly, since 2000, the OCTC has been conducting a random review of closed cases. The purpose being to try and ensure that actions taken by OCTC are consistent with the office's procedures and policies, and that the substantive decisions that the office is making on cases are within an acceptable range of prosecutorial discretion and comply with statutory provisions and case law. This audit was established in 2000. Originally, it was conducted by team leaders and assistant chief trial counsels within OCTC with a summary prepared by the deputy chief trial counsel. That summary report then went to OCTC management for identification of training issues, policy issues, and corrective actions. In 2006, responsibility shifted to the newly reestablished OCTC Audit and Review Unit with, again, an internally prepared summary report. In 2010, in response to a 2009 recommendations by the state auditor, OCTC established formal procedures for the management team to follow up on and implement the recommendations from the review. And in 2012, to try and ensure the independence of the audit process, the responsibility for conducting the review was shifted from internal personnel within OCTC to an outside counsel who was retained to conduct the audit and prepare the summary audit review. So what the audit consists of is essentially twice a year, 250 files in total are selected in random. 100 of those are ones that are closed at intake, 100 are those that have been closed or resolved at the investigation stage, and 50 are those that have moved past the investigation stage to pre-filing or trial level by closure or a non-disciplinary resolution. So this doesn't encompass cases that actually move forward to trial. The review is basically a compliance with closing procedures, whether the documentation is accurate and appropriate, and whether the actions taken are consistent with case law, charging standards, and office policies and procedures. And the recommendations can take a variety of forms. There can be recommendations for training. There can be recommendations for modifications of policy, or there can be specific corrective actions, including, for example, the reopening of closed files to address issues that the auditor believes weren't appropriately addressed. Our most recent audit involved an audit of files closed or otherwise resolved during this 6-month period. That looks like it was a long time ago, and it was. Generally, there's a 6 to 12-month lag due to the time necessary to select and review the files, but in this case, it was further delayed by COVID-19. So the audit report wasn't prepared and provided to OCTC until June 7th, 2021. This today is the first time that we've done this, sharing the results and our response to those results with RAD. We asked the auditor this time to prepare an executive summary without identifiers for individual cases so that it could be shared in open session. And we in turn prepared a response that again also does not refer to individual cases in a way that could be identified. So it too could be reviewed, and it outlines our agreement, disagreement, and certain actions taken. Our goal is to hopefully increase transparency and enable additional RAD oversight. So in summary fashion, the overall results, there were 26 files that only had technical errors regarding failure to post information to Odyssey. We are continuing to make efforts to revise our policies and procedures relating to Odyssey so that they are clearer and so that everybody has clear instruction on what does and doesn't need to be posted on our online case management system. 94 files had one or more substantive areas, and those are of varying levels. Some of them were very technical. Others, as we'll see when we turn to the next slide, were more substantive. This number of files with errors was consistent with prior audits in which 95 and 81 issues were identified. So the substance of the audit findings and a breakdown of the major findings. First, they identified errors in identifying and investigating issues of possible misconduct. This was in a total of 13 files, and of those, the auditor recommended reopening 8 files. This recommendation too was consistent with prior audits in which the auditor had recommended reopening of from 9 to 12 files. OCTC agreed with the auditor's recommendations and has reopened those 8 files for further investigation and analysis to determine whether, in fact, additional action is required. The auditor identified 5 files in which the auditor believed there was duplicative overcharging and an improper evaluation underlying that. For reasons we've laid out in the memo we provided, we disagree with that and believe that in fact this was basically alternative charging. In other words, charging alternative violations supported by the same facts and or effectively charging lesser included offenses or the equivalent of that. In 2 files, the auditor concluded that we had proceeded to default disbarments in cases where that should not have happened. Again, for reasons set out in the memo we provided, OCTC disagrees and believes that in fact those disbarments were supported by evidence and that the default proceeding by default was consistent with the respondent's failure and refusal to respond and participate. In connection with the content of notice of disciplinary charges and our handling of litigation issues, the auditor identified 22 files in which there were errors, or in which the auditor identified errors. That was more than double the number of cases as the prior audit. This includes the 7 files involving the auditor's perception of duplicative overcharging and improper pursuit of default disbarments. The majority of the other issues raise training issues on which OCTC agrees. For example, an erroneous filing for summary review when the issues raised would not qualify for such review, publicly filing a document that should have been filed under seal, improperly arguing that collateral estoppel was a basis for proving a case, and in some instances filing motions with information that was not sufficient or as complete as possible to support the action sought. Again, those raised training issues with which we agree. Another area of concern that the auditor identified was the content of closing letters to complaining witnesses. There were 17 files in which the auditor addressed issues. Again, we believe these raised training issues with which we agree, primarily relating to how much substance should be providing to complaining witnesses to let them know that we have in fact recognized and addressed all of the claims that they are raising. Other findings involved compliance with office policies and some of the other errors already identified. Again, to the extent those raised training issues, which the bulk of them seem to, we agree with that and will pursue additional training. There were also proposals for modifications to the procedures by which we select the files for audit. We agree with those and we'll be adjusting those for the upcoming audits. So that's a summary of the findings and our response. And I guess our primary question for consideration here is this useful to RAD? And do you want us to continue similar reporting on the audit and our response to the issues identified by the auditor?
Madam Chair, this is Brandon.
Please go ahead.
So this is one of the issues that we took up yesterday on the RAD leadership biweekly meetings, and it's something that was discussed at length with Melanie Lawrence and Steve Moad. And I think there was this thought that this really provided an insight into the inner workings of prosecutions and provided RAD with a unique opportunity to see if there were any sort of systemic issues, any policy issues that needed to be addressed, especially in the context of the ad hoc commission and some of the ongoing discussions that are taking place there. And I would note that one thing that really jumped out at me was this issue of overcharging, duplicative charging. OCTC's response that is appropriate given case law in state bar court, and really that it is OCTC's obligation under existing case law to pursue charges that have factual merit. And so one of the things that the state bar court does is ensures that there's no double punishment, but yet there's this opportunity to litigate all potential misconduct. So I think there's some correlations with the response here, plus the work of the ad hoc committee. But going back to this time for RAD to exercise some additional oversight, I think this is really beneficial. You know, an auditor is going to have access to files, may not have access to all of the information in the entire universe of OCTC. And so allowing OCTC to provide that response, I think gives us kind of an opportunity to see what a perception is regarding a particular case file, and then what OCTC responds with as to why there is that perception. So I think it's beneficial. And Mr. Cardona, I don't know if you have any insight coming in to this position and now all of a sudden presenting on the OCTC's recommendations and things you've learned. Have you found that it's a beneficial tool?
I mean, yes, I think it is very beneficial to us to have the audits done and to review those and actually to prepare the response. So I would be in favor of doing this on a going forward basis, because I think it does provide a couple of things. One, it provides some transparency to the public who can watch these meetings and see what the auditor is actually finding in a random review of closed files and how we respond to that, which I think is helpful in trying to ensure that the public has confidence in what we're doing and can see, you know, precisely what you've said, how an independent person is coming in and reviewing those files, what they're finding and what our response is. I think that's beneficial. And I would be in favor of continuing doing this going forward.
Madam Chair, if I could put myself in the queue after Trustee Sowell, I'd appreciate that.
That would be great. Go ahead, Mr. Sewell.
Thank you, Madam Chair. George, just a quick question, and that is that, well, first of all, just a comment. I also, as a non-lawyer, believe this is of a real benefit to those of us that are on the board, as well as to sort of our stakeholder community. So would be in favor of absolutely of this, the audit continuing and this information being presented to us, the folks on the board. I have even though it was a sort of a small subset of the cases that were audited that are being recommended for additional sort of review and investigation and reopening. I just had a question about that. As a non-lawyer, the only thing I could think of is, does that sort of somehow subject those folks who are going through an investigatory process a second time to some sort of double jeopardy, or what is the what sort of happens as a result of those cases being reopened?
So reopening it simply means that we would take a second look at the information to determine whether in fact there is a basis for proceeding with charges. Those files had been closed without any pursuit of disciplinary charges, so there had not yet been anything done. So there wouldn't be any, equivalent of double jeopardy to the extent that that might be the concern. And it's not certain that in fact we will pursue discipline in those cases. It's simply that we've reopened them to take a look, potentially do additional inquiry, and then make a final determination as to whether there's a basis for pursuing disciplinary charges.
Very good. Thank you.
Mr. Duran?
Thank you, Madam Chair. Thank you, Mr. Cardona. And I would answer your question that you posed to the committee in the affirmative. I think this is very useful information, and I think it represents some important transparency in the process. And as Brandon suggested, sort of cementing further RAD's oversight of your office and what you're doing. Brandon also mentioned the ad hoc commission on the discipline system, and as you were presenting, that thought struck me as well. I think that the members of that committee or commission would be very interested in what you presented. I'm going to add a little bit additional thought of what might be of interest to those of us on the committee, and that is the statistics that you provided. Is there further data on the ethnic background of the attorneys whose cases were perceived all the way across the board, whether there's double charging and what needs to be open? Do we have that data available? Is that something we could garner?
I don't have that data. We would have to go back and see if we have a mechanism for gathering that.
Okay. All right. I would suggest that it would be worth looking into to see if it's not too difficult or expensive to sort of do that extra level of analysis, since it coincides very importantly with the fairness piece of the ad hoc commission's work. That's all I have, Madam Chair. Thank you.
Thank you. Any other questions? And I have some of my own. Okay, hearing none. So I have a sort of in the weeds question and then a broader policy-based question. One is, what percentage, and apologies if you said this, but what percentage of closed cases does that 250 number represent? In other words, what percentage is the audit looking at?
It's a very small percentage. So we get, depending on which year you look at, somewhere between, I believe, 12,000 and 16,000 complaints. So 250 closed files would reflect a small percentage of that, but they are selected at random with the assistance of Araya.
Got it. Thank you. And then I guess a broader question is, I would be curious I agree that this is very effective and we should keep doing it. I think one thing that would help us in RAD exercise oversight and to better understand what issues are out there is to understand whether there are recurring issues, right? So you gave us numbers that go to, this number of errors is consistent with what's been found in the past, and OCTC agrees that there's a training issue. Is the training issue recurring? I mean, so it would be helpful to understand, is there something that points to trainings not having been effective in the past? Or are there new issues that are coming up? Are we seeing certain issues that point to perhaps a need for structural change or policy issues we should consider? I think getting into the substance in addition to the numbers would be helpful.
Okay, we can try and do that. with our next report, since we do have an audit underway for the next set of cases. That would be the next time period. So we can certainly look at trying to include some of that when we come back the next time.
Okay, yeah, I mean, I think it would be helpful to know if, you know, you're seeing the same types of errors pop up again and again, that perhaps speaks to a deeper issue that could be addressed in a different way.
Yeah, I will say there will be some issues that pop up again because many of the things that are identified by the auditor are fairly technical issues that I think reflect the amount of time that people spend and the amount of care they put into sometimes technical tasks like entering data into Odyssey or the actual preparing of the closing letters. So I think we are going to see some recurring letters, but obviously we can look at that and see exactly what they are and whether they do, as you suggest, indicate a need for, you know, training in particular areas or potentially some structural changes.
Great, thank you. Other questions or comments? Okay, seeing none, thank you, Mr. Cardona, for that presentation. This does conclude the open session agenda. We are now going to move into closed session to discuss the items on the closed session agenda, the Rule 2201 case status update, and the evaluation of the Chief Trial Counsel. These items are in closed session pursuant to Government Code Section 11126A1 and 11126C2. The committee will now disconnect from this webinar and we will reconnect using the closed session link that has been provided by staff. Thank you, everyone. See you in closed session.
Thank you. Hello, everyone. This is Jose Cisneros, State Board of California, returning into open session for the Regulations and Discipline Committee, the committee has pursuant to Government Code Section 11126A1 and 11126C2 met in closed session. At this time, there is nothing to report out of closed session. And with that, completes all the matters before the committee today, and this committee meeting is adjourned.
Mr. Vice Chair, if I could, before you adjourn us out, I do note that the Board of Trustees meeting is scheduled to start now right at 1 p.m. I would like to ask staff to let whomever's waiting in the Zoom universe know that we're going to bump that back to 1:20 to give the board a chance to take a break. We've been going since early this morning and grab a quick bite. So with all due respect and apologies for the delay, we will start at 1:20.
Thank you very much.
Thank you.
Thank you, everyone.